Addressing Housing Code Violations in Your Unit, presented by the District Office of the Tenant Advocate. Disclaimer. The information provided in this tutorial video does not and is not intended to constitute legal advice. Instead, all information and content are for general informational purposes only. The OTA is an independent district agency charged with providing legal, policy advocacy, emergency housing, education, and outreach services to district renters. In the District of Columbia, the Housing Code was promulgated for the purposes of preserving and promoting the public health, safety, welfare, and morals through the abatement of certain conditions affecting residential buildings and areas, including dilapidation, inadequate maintenance, overcrowding, inadequate toilet facilities, inadequate bathing or washing facilities, inadequate heating, insufficient protection against fire hazards, inadequate lighting and ventilation, and other unsanitary or unsafe conditions. Housing Code. The landlord must ensure that the rental unit and all common areas are safe and sanitary as of the first day of the tenancy. This is known as the warranty of habitability. This warranty is implied into every lease in the district and is also explicitly required by district regulations. The landlord must also maintain the unit and common areas of the building in compliance with the Housing Code. When there is a Housing Code violation, the landlord must make necessary repairs to bring the unit into compliance with the Housing Code. Requesting that your landlord make necessary repairs is a protected tenant right. DC Housing Code Standards. The DC Housing Code is detailed and extensive and covers both the interior and exterior of residential rental units. The Department of Buildings, or DOB, is mandated to ensure public health, safety, and welfare by enforcing property maintenance codes on all residential structures in the District of Columbia. Common Housing Code violations include infestations of mice, rats, cockroaches, and bedbugs, holes in walls or ceilings, broken and/or unsecure windows or doors, unsecured door frames, inadequate heating, broken appliances, leaking faucets and toilets, unsanitary or unsafe conditions, peeling paint, cracked plaster, water damage, decaying wood, or no utilities, lack of water, gas, and electricity. Insects and pests. The landlord must maintain your unit and all common areas of the building in compliance with the Housing Code, including keeping the premises free of rodents and pests. So, if a tenant's unit is infested, who's responsible for the cost of extermination? It depends on the number of affected units and on the actions taken by the landlord and the tenant. Some factors to consider: preventative building inspections, routine building exterminations, number of units affected, and the tenant's maintenance of their dwelling unit. Mold. Under district law, landlords are required to take action if a tenant notifies them of the presence of visible mold in their unit. Always examine damp and poorly ventilated areas in your home. If you suspect mold in your apartment, send an email or a letter to your landlord about the mold. After receiving a tenant's email or letter, the landlord must perform an inspection of the mold within 7 days and remove any mold that is found within 30 days of the inspection. If a moldy area in your apartment is 10 square feet or more, your landlord must use a licensed professional to assess the mold problem and another licensed professional to eliminate the mold. For assistance with mold issues, tenants should refer to the Department of Energy and the Environment. Heating and air conditioning. Landlords must provide heat from October 1st through May 1st. During this period, the temperature must reach at least 68 degrees Fahrenheit during the day and 65 degrees Fahrenheit at night. Landlords are not required to provide air conditioning, but if they do, they must keep it in good working order. The interior temperature of your unit should be at least 15 degrees Fahrenheit below the outside temperature. If air conditioning is provided, it must be turned on between May 15th and September 15th. Document Housing Code violations, photographs and videos. Always make requests for repairs in writing. Always take pictures and videos of the suspected Housing Code violations. Label each photograph with the date, time, and specific location where the picture was taken. Make sure the picture is clear. Narrate while recording a video. State the date, time, and specific location of the housing code violation. Include any facts that assist understanding the problem, not commentary. So what should you do if you believe your residential rental accommodation does not comply with the DC Housing Code and your housing provider does not make the necessary repairs? Tenants have two avenues to address unabated housing code violations. They can request a housing inspection from the Department of Buildings, or they can file a complaint to enforce the housing code at Housing Conditions Court. The Department of Buildings conducts property maintenance and housing code inspections. Call them at 202-671-3500. Call 311 to request an emergency inspection. The DOB issues two types of notices: a Notice of Infraction Emergency, or NOIE, and a Notice of Infraction Routine, or NOIR. An NOIE or NOIR identifies violations of the DC codes and/or regulations and orders a landlord to abate or fix the violation within a mandatory time period. When landlords are issued an NOI, they are also issued a civil penalty or a fine. Emergencies include life safety issues like carbon monoxide, lack of heat, or hot water. The life cycle of a housing code inspection in 8 steps. Step 1. Residents can report possible housing code violations to the DOB by calling 202-671-3500 or filling out an online inspection form. Step 2. The DOB schedules and conducts an initial inspection. Inspection is completed within 24 hours of a complaint for emergencies and within 15 to 20 days of a complaint for routine maintenance inspections. Inspections can be done in person or virtually. Step 3. After an initial inspection, an inspector will document any violations, and either an NOIE or NOIR, or both, will be generated. NOIEs must be abated within 24 hours. NOIRs may be abated within 60 days as long as any associated NOIE is also abated in a timely manner. Step 4. A landlord is served any NOIE or NOIR via email or US mail. The tenant is also entitled to a copy of an NOIE or NOIR for their unit. Step 5. If the landlord abates any NOIE within 24 hours and an NOIR within 60 days, then those violations qualify for deferred enforcement and will not be filed, or will be dismissed without fines. Proof of abatement can be provided online. DOB will schedule a follow-up inspection to verify abatement. Step 6. If the landlord fails to abate the violations, the NOIE or NOIR is also filed at the Office of Administrative Hearings, or OAH. NOIs from the same inspection are filed together. Step 7. A landlord can admit the cited violations and pay the fine associated with the NOI, deny the violations, or admit the violations with an explanation. If the violations are denied, OAH will schedule a hearing. For more information, visit the OAH website at oah.dc.gov. Step 8. A landlord may contact DOB's Alternative Resolution Team, or ART, for options to resolve a case other than OAH. Please note that ART will require all violations to be abated. DOB Proactive Inspections. DOB schedules proactive inspections for residential buildings citywide. While tenants cannot request that DOB conduct a proactive inspection at their building, multiple tenants from one building can request building-wide inspections, and these are often scheduled together. Tenants may also file a complaint to enforce the housing code at the Housing Conditions Court, or HCC, nicknamed Fix-It Court. HCC is a court of limited jurisdiction that specializes in actions to enforce the district's housing code regulations. The judge at HCC can order the landlord to make repairs to a tenant's unit or common areas of the housing accommodation. To initiate a case, a tenant plaintiff must file a complaint and summons with the Civil Actions Branch Clerk's Office, Moultrie Courthouse, Room 5000. A copy of the complaint and summons must then be served, or giving official legal notice, to the landlord defendant. The tenant plaintiff is responsible for serving the landlord at least 8 calendar days in advance of the hearing. HCC's cases will have the first hearing scheduled less than a month after the suit is filed. For more information on filing an HCC complaint, please view our tutorial video on the Housing Conditions Calendar Court on the DC Office of the Tenant Advocates YouTube channel. Tenant petitions. Tenants that live in rent-controlled units may also file a tenant petition with the Rental Accommodations Division, or RAD, to challenge a rent increase based on claims such as, but not limited to, the services and facilities have been reduced in the building, including the existence of substantial violations of the housing regulations, or the rent was increased while the unit was not in substantial compliance with the housing regulations. Withholding rent. OTA does not advise tenants to withhold their rent. Tenants seeking monetary relief or damages for the condition of the property must file a breach of contract claim in small claims court. The law limits small claims court to only hear cases from plaintiffs seeking relief in an amount under $10,000. Tenants may file a counterclaim or use housing code issues as a defense in their case in landlord and tenant court. Quiet enjoyment. The landlord must make reasonable efforts to address disturbances caused by other tenants in the building. The landlord may make any necessary repairs, but may not unreasonably interfere with the tenant's quiet enjoyment of the premises. The landlord must give the tenant a 48-hour written notice to enter the unit in non-emergency situations. Landlords can only enter Monday through Saturday from 9 to 5, excluding federal holidays. If you have questions or concerns about tenants' rights in the District of Columbia, please contact the OTA Tenant Hotline at 202-719-6560 or visit our website ota.dc.gov or our social media @OTA@DC.